Welcome to The Defense for Us, the podcast where we explore the captivating world of criminal trials through the lens of a criminal defense attorney. My name is Rachel Diane. In this podcast, we dive deep into the intricacies of criminal trials, the tactics that are used by the prosecution, the strategies that are explored by defense attorneys, and the very critical decisions made by judges that shape the outcome of a trial. And as always, the makeup that is being used is from my own company. You will be able to purchase it at www.myroyaltycosmetics.com, and a portion of all the proceeds that I generate from this cosmetic business will be donated towards free legal aid for women that are currently being prosecuted by the government that were sex trafficking victims, as well as children living in inner cities. And for all of those that are listening through the podcast, just so you know, if you would like to follow along visually, you will be able to also watch me break down this trial on YouTube. While I'm on YouTube, I use a lot of visual aids, so images of the prosecution, of the defense, the judges, as well as the witnesses that are called to the stand. I also put in a lot of images of the actual evidence as well. So of the evidence that is presented at trial, whether it's recordings, pictures, anything, it's also inserted into the YouTube video as well, so you're able to visually follow along and see what the jury actually was presented as well. And today is part 2 of the People versus George Zimmerman, also known as the murder of Trayvon Martin. In order to get caught up to where we are right now, please refer back to part 1 for the first half of this trial. As always, when it comes on to putting on the case, which is about to start, the district attorney always goes first, because they always have to put on a case, because they have the burden to prove the case and prove every single element beyond a reasonable doubt. And the defense doesn't have a burden at all. And if they wanted to, as you'll hear many district attorneys say, even though it never happens, the defense doesn't have to do anything. They don't have to object. They don't have to put on a case. They don't got to do shit, because the burden's on the people. Now, a defense attorney would never just sit there and do nothing. We'd probably lose our legal license, you know? But on top of proving every single element beyond a reasonable doubt, they also have to prove beyond a reasonable doubt that George Zimmerman was not in fear for his life. They have to prove beyond a reasonable doubt that George Zimmerman was not acting in self-defense, because that's what the defense is arguing, right? And the defense doesn't have to prove this beyond a reasonable doubt. The district attorney has to prove beyond a reasonable doubt that it didn't happen. So the district attorney now begins calling their witnesses, and they call somebody by the name of Chad Martin to the stand. And at this time, he's 15 years old, and he testifies that he knows Trayvon through Tracy Martin, right? And that Tracy Martin is his mother's fiance. So Trayvon Martin was basically like his stepbrother. And he testified that on the day of the murder, him and Trayvon were playing video games on his PlayStation 3, and that Chad was like, hey, I kind of want to get some stuff from the corner store. And so Trayvon was like, okay, cool. I'll go run to the corner store and I'll go pick it up. I'm going to go grab me like a fruit juice, like an Arizona iced tea watermelon juice. What do you want? And Chad told him that he wanted Skittles. They then called the 7-Eleven clerk to the stand, and he testified that yes, that's him and the surveillance footage, and he is the one that's selling to Trayvon Martin. And what he sold to Trayvon Martin was an Arizona watermelon iced tea, as well as a bag of Skittles. He said that Trayvon paid in all cash and that he was not a suspicious person at all. And that he wasn't acting suspicious, he wasn't acting weird. There was nothing out of the ordinary of this kid buying Skittles and a drink. So next they called a man by the name of Sean Nofke to the stand, and he was actually the non-emergency dispatcher for the 911 Sanford police entity. And they called him for multiple reasons. One, because you have to lay foundation before you can play a 911 recording, and the only person that's going to be able to lay that foundation is the dispatcher or the custodian of records of these 911 phone calls. And then the other reason why they called him as well was obviously to question him. So after he laid down the foundation for these 911 calls, he testified that when he told Mr. Zimmerman, George Zimmerman, to not follow Trayvon Martin when he said, oh, we don't need you to do that. He testified that he actually was not giving George Zimmerman an order, that he's legally not allowed to give orders like that due to liability. And it was more of just a suggestion in order to protect the safety of this caller from this person that they're alleging is really suspicious. On cross-examination, this witness testified that he didn't believe that it was out of the ordinary for Zimmerman to identify this person, the suspicious person, as African American, that he thought the only reason why he was doing that was for identification purposes. So next, an officer by the name of Ricardo Ayala was called to the stand, and he said that he arrived, and when he arrived, that there was already an officer there at the scene named Timothy Smith, and he was holding George Zimmerman at gunpoint, right? And that there was another person on the grass laying face down, not moving, and that he yelled at the person on the ground to show your hands. But the person wasn't responding. So he ended up turning the body over, saw that the person was unresponsive, and started giving CPR. He said that it was too late, that the person that he was trying to give CPR to was already deceased. On cross-examination, Ayala testified that Zimmerman was not confrontational at all, and in fact that he was very easy to work with, and he complied with all of the requests that the police were asking of him. So then Officer Timothy Smith came to the stand and testified. Now, he is the person that was first on scene, right? And he testified that when he came onto scene, he saw Zimmerman standing there with the gun, right? And he saw that Trayvon Martin, who they later identified as Trayvon Martin, was laying on the floor in the grass face down. He said that he drew his weapon on Zimmerman, and Zimmerman was completely compliant, and Zimmerman said to him that I killed that man in self-defense. I was screaming for help, and that nobody was coming to help me, and that this man was slamming my head multiple times against the concrete and punching me multiple times, and he was going to kill me, so I had to shoot him in self-defense. Officer Timothy Smith also testified that when he saw Zimmerman, his nose was bleeding. He had a cut to his nose and his nose was bleeding, and that he had some lacerations and bleeding to the back of the head, and that the back of Zimmerman's jacket was wet and did have some grass on it. He also testified that he told Zimmerman, hey, if your head was being slammed against the concrete this many times, to the point of somebody was trying to murder you by slamming your head on the concrete, you should go to the hospital. Do you want to go get medically checked out? Zimmerman refused medical treatment. He wouldn't let the medics look at him. He wouldn't get into the ambulance, and he would not go to a doctor to get x-ray scans or any type of inquiry into how he obtained these medical issues, how he obtained these lacerations, if there was any fractures. He just refused medical treatment. So now we're going to start getting into the demise of the prosecution's case, because at the end of the day, although the judge played a huge role in the reason why the outcome of this case came out to the way it was, the prosecution did a terrible job. This was People versus O.J. Simpson all over again. They took a case and completely failed. Okay, so the first witness that the prosecution calls, where their case begins to fall apart due to a complete lack of skills on their end of litigation, is an officer by the name of Doris Singleton. So they called her to the stand, and Doris was the officer that questioned George Zimmerman the night of the murder. So she was testifying to everything that George Zimmerman had told her. And this is just really confusing. We'll get into why this is confusing in a moment. But she testified that George Zimmerman told her that at Twin Lakes or Twin Peaks, whatever this residence was called, that this gated townhome community had been the scene of a series of recent burglaries, and that throughout his entire neighborhood there have been all these strings of like very violent robberies and very violent burglaries. Even when the residents are in their home, they're being burglarized. and that this was just a widespread concern throughout the entire neighborhood, so much so that they created a neighborhood watch, and that he had become in charge of that neighborhood watch in order to help protect the community. So Officer Doris Singleton continues her testimony, and she says that Zimmerman told her that on the night in question, that Trayvon Martin looked really suspicious. And the reason why he looked really suspicious was because it was raining, and it was raining relatively hard that evening. And that Trayvon was just leisurely walking through the neighborhood. And he continues on to tell her that night during the questioning that Zimmerman was emphasizing that he knows everybody in the neighborhood. Like every single person that lives there, he knows. And that Trayvon was unfamiliar, that he didn't know who Trayvon Martin was, but he knew every single adult, he knew every single child, every single teenager that lived there. But Trayvon was a stranger, and he has never seen him in the neighborhood before. She then continues testifying that Zimmerman told her that night that Trayvon was also suspicious because he began circling Zimmerman's car when Zimmerman was parked in front of the clubhouse. He carried on saying that Trayvon was also suspicious because he jumped out of the bushes out of nowhere and started punching him in the face and banging his head against the concrete. Basically, she was called to the stand as a state witness, and she ended up doing so poorly, or I guess so well, that she ended up becoming a defense witness. So essentially the prosecution did so poorly at direct examination that they just let her get up there and retell Zimmerman's story. So now the jury is consistently hearing this story over and over and over again. They heard it on the recording, right? With the 911 dispatcher somewhat, because it is very inconsistent. Then they heard it through other officers, right? Because there's a reenactment, and now they're hearing it again through the questioning. They keep hearing the story be repeated. To be honest, this was terrible. I would have asked, how many times has George Zimmerman called the 911 dispatcher non-emergency line in the past 3 months? When did these calls begin accumulating? When was the first time he called? What profile was he giving? Because I can't say racial profiling, but I can say profile. What profile for identification were they giving? And then this woman's going to say black. I'm allowed to ask about profiling, but not racial profiling. You see how lawyers get around things? I would also ask her, okay, so you're testifying right now that George Zimmerman, he told you that Trayvon Martin jumped out of the bushes and sucker punched him and attacked him. Is that correct? She's going to say yes. Pull up the motherfucking video of the reenactment, pause it right where Zimmerman is standing, where he says this is where he was sucker punched, where Trayvon Martin came out of nowhere, and ask her, please point to the bush. Please point to the bush that George Zimmerman said that Trayvon Martin jumped out of. And just stand there and let her look like an idiot. And it's not even her. George Zimmerman's going to be the one that looks like the idiot because there was not a single bush in that area. You're testifying that on the night of questioning, Zimmerman told you that he was sucker punched and that he was fighting for his life, and he was holding his hands up in self-defense as Trayvon Martin was punching him numerous times. Can you please show me the bruises? Can you please point out the bruises on Zimmerman's arms? They're going to say no. You're going to ask why. Why can't you do this? Why didn't take any photographs? Why didn't you take any photographs of his arm? Aren't you trained to take pictures and videos of injuries after a crime has occurred, especially a murder? And they'll be like, yes, I am. Okay, so why didn't you take any pictures? There was no bruising. The state just did so terrible. This witness could have completely torn apart what George Zimmerman was claiming. Completely and utterly ripped it apart, but the prosecution failed. So the next and final police witness that the district attorney calls is Detective Christopher Serino, and he was the lead detective in this case. But this testimony also did not go well for the state, and there is numerous reasons why it wasn't going well. First of all, this detective is not coming in like willingly. He actually hired his own criminal defense attorney. He actually hired the same criminal defense attorney that Casey Anthony hired to represent her. And he didn't hire this defense attorney because he did anything wrong. The reason why he hired them was because he was forced to do so many things that he didn't agree with. He was first really scared of being held civilly liable by George Zimmerman, because George Zimmerman claimed stand your ground, and he still went forward with asking for certain charges to be pressed, right? And under the Florida law of stand your ground, you can be sued civilly if you don't like respect the stand your ground claim by the defendant. The next issue came in is that when this crime had occurred, Christopher Serino stated many times, especially on interviews to the press, that was angry that no charges were brought. He stated numerous times that there was no probable cause for an arrest, that George Zimmerman was claiming stand your ground, and that there was enough evidence, a preponderance of the evidence, to prove that, hey, there's a 50% chance that he's telling the truth. And by stand your ground law, that's all he needs. There's no probable cause to arrest him. But then the public keeps getting angry, right? So then he writes like kind of like a letter, a motion, a request to the state being like, hey, can you please press manslaughter charges? But the state didn't end up pressing manslaughter charges. They ended up pressing murder charges. Like, the evidence showed that because he really was being forced to do so many things that he didn't agree with, he rewrote his police report like 7 or 8 times. But even with this police officer, the district attorneys have once again completely dropped the ball, and they essentially just gave another witness, another police officer, the stand to retell George Zimmerman's story. They went over the recording of the reenactment with George Zimmerman, and they basically showed the reenactment and let George Zimmerman have yet another platform of telling this same narrative over again. And they weren't trying to contradict the narrative. They weren't trying to pull the narrative apart. They were just kind of letting it be told. But Serino did testify that there was evidence that when George Zimmerman used the term, these fucking punks, these fucking assholes, that there was spite and hostility in his voice and in his sentiment and in his statement. Now that's important because the district attorney, again, they need to prove spite in order to get second-degree murder, but that doesn't amount up to enough spite to get second-degree murder. Serino also testified that there was evidence that Zimmerman may be exaggerating the amount of times he was hit or to the extent in which he was hit as well. And he also testified that there was no evidence that Trayvon Martin was doing anything wrong when he was profiled by Zimmerman as an assailant. Upon cross-examination, this witness basically just turned into another plus for the defense. He testified that, yeah, like, although there's no evidence to show that Trayvon Martin wasn't doing anything wrong and wasn't acting suspicious, there's also no evidence to rule out that he was doing something suspicious. Trayvon Martin was killed. They did a search of the surrounding areas, and they found this like wire hook. Not on Trayvon Martin, not anywhere near him, but they found this wire hook in the area that could possibly have been used to break into windows. Did the district attorney ask on redirect, did you test it for DNA? Was Trayvon Martin's DNA on it? How far away was this piece of wire from Trayvon's body? Was it 100 yards? No, they didn't ask any of that. Of course not. So then Officer Serino was asked by Mark O'Mara, do you believe that George Zimmerman was telling the truth? And the detective answered, yes. I believe he was telling the truth about that night. This is fucking huge. Why this wasn't objected to before he can even give his answer? Literally, Mark O'Mara just has to say, do you believe? My answer would be like, objection, speculation. I'm not even gonna let you finish. Objection, speculation. And if the judge says, Rachel, shut the fuck up, and let him answer his question, ask his question before you have an objection, fine, I'll be quiet. And then the second he says, do you believe that George Zimmerman was telling the truth? Again, objection, speculation. Objection, asking for a conclusion. Objection, asking to talk about the truthfulness of another witness. But no, the district attorney did not do any objection. In fact, they let the jury sit with that for an entire day, and the media tore it apart. The media was like, what the fuck? Why did you not object to this? This is awful. Now the jury's going to believe the officer because the officer believed George Zimmerman. And in fact, it wasn't literally until the next day, 24 hours later, that the prosecution goes, Your Honor, we would like to make an objection because that was an improper question. And the judge goes, yeah, it was. jury disregard what he said, they're not going to disregard it. The damage is done. So now we're going to get into the testimony of a woman by the name of Rachel Jean Tell. And she was supposed to be the glue of this case. She was supposed to blow Zimmerman's statement wide open, right? So what had happened and how Rachel Jean Tell was even found was there was a letter that was sent to Trayvon's mom, Ms. Martin. And the letter was from Rachel. And she claimed that she was actually on the phone with Trayvon while he was being murdered. And she wrote out everything she heard. And this was before this even became a media circus. Like she wrote this letter like almost right after he was killed and sent it off to her about what had happened. She gave this letter to Benjamin Crump. Benjamin Crump got the phone records of Trayvon Martin and saw that he was on the phone with somebody at the time of the murder. They then were able to subpoena the phone records, find out who that phone belonged to, and find Rachel Jean Tell and get her story. So she is going to say the exact opposite of the story that George Zimmerman is claiming. And this witness was so vital to the case. And again, she ended up just getting ripped apart on the stand. The district attorneys did not do their job, and she was just a play toy for the defense. And although the district attorney's case has already begun to fall apart, and they've already begun to lose with every witness that they're calling, this really cemented their loss. And I'm going to read to you the letter that Rachel wrote to Miss Martin on March 19th of 2012. She writes, on March 19th of 2012, I was on the phone when Trayvon decided to go to the corner store. It started to rain, so he decided to walk through another complex because it was raining really hard. He started walking, and then he noticed that someone was following him. Then he decided to find a shortcut because the man wouldn't stop following him. Then he said the man didn't follow him again. Then he looked back and saw the man again. The man started getting closer. Then Trayvon turned around and said, "Why are you following me?" Then I heard him fall, and then the phone hung up. I called back and I texted, but no response. In my mind, I thought it was just a fight. Then I found out of this tragic story. Thank you. So the state turns over this evidence to the defense because they have to, right? They're going to use it. So they turned it over to the defense before they ever even got to trial, well in advance of trial. And what happened when the state got this evidence, what happened when the defense got this evidence was that they held a deposition. And a deposition is basically subpoenaing all these witnesses, sending out subpoenas to all these witnesses, forcing them to show up somewhere to be deposed, to be questioned by the defense. And there's usually a court reporter, and you can object and all that stuff. And it's under penalty of perjury. And if you have the money to do this is something that you should ask your defense attorney to do, because you want your defense attorney to be as prepared as possible during trial, because they're going to ask a lot of the same questions in trial that they asked during the depositions. They're going to find out so much more information that may lead them to other strategies, other defenses, other evidence, other witnesses, other things that they need to do. But most importantly, as you're going to see here, the defense attorney is going to be able to learn about the witness. Meaning they're going to be able to push their buttons and manipulate them to have the jury see that witness in an uncredible, unreliable way. So at this deposition, it really was not going well for Rachel. It was a big foreshadowing for the prosecution to see how terrible it was also going to go at trial. But essentially, at the deposition, Rachel testified that, she had a lot of guilt, about Trayvon's death, and that she essentially felt responsible for it because she was actually the one that told him to run. So she testified on the deposition that on the night in question, she was on the phone with Trayvon when he decided to go to the corner store, and they were talking the entire time. And it eventually ended up raining. And so Trayvon was not familiar with this area, was not familiar with the neighborhood, but he was trying to look around and basically see if there was a shortcut to the complex where he was staying at, to the unit where he was staying at. And he said, like, at some point, like, hey, this is really weird. There's this guy that's following me, right? And he's following me in his car and he won't stop following me. And she tells him, and she testifies that she tells him, you need to run. Like, you need to get the fuck out of there. Like, you said that this is a creepy ass cracker, because that is how he described him. That's how she testifies that he described him. That this is a creepy ass white man, and that you need to run. This white man could be trying to rape you. This white man could be trying to kill you. This white man could be like trying to harm you. Like, why else would he essentially be stalking you right now and following you? So Trayvon does. He like begins to run. And then she testifies that while he's running, he's telling her like, oh my fucking God, this guy is still following me, right? So she's like, oh, you need to run faster. You need to run faster. And then he tells her like, oh, okay, like, I think I lost him. I don't see the guy anymore. But then she says that he turns around and he tells her like, oh my fucking God, like, he's still there. Like, he's coming up to me. And she testifies that she tells him like, Trayvon, you just need to leave. Like, you just need to get like the hell out of there. And he says, no, like, I need to know what the hell this guy's problem is. And so she testifies that she hears Trayvon go, hey, like, what's your problem? Like, why he says like, hey, what's your problem? Like, why are you following me? And that she hears a man in the background, and she's unfamiliar with the voice, but the man asks him, what are you doing in my neighborhood? Why are you in my neighborhood? She says that she hears like a tussle, and she can hear wet grass sounds. Like, she can hear an altercation happening on the wet grass, and that she's yelling out, Trayvon, 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 and that she's not getting any response back. And then the phone line goes dead. So then this is where the deposition begins to fall apart, and you can see that the defense is just going to like eat her alive. There's multiple things here. First of all, they showed her the letter that she had quote unquote written and sent to Trayvon's mom, and she couldn't read the letter because she couldn't understand it because she didn't know how to read cursive. And so she told the defense attorneys under oath during the deposition that the reason why she could not read the letter and the reason why she couldn't understand cursive was because her friend actually wrote it for her. That she told her friend what to say, and that her friend wrote it out, and that she felt like this letter needed to be like formal and like more serious, and therefore it required cursive, and she didn't know how to write or read cursive. She also wrote a false name and gave a false age. So she lied about who wrote the letter and about the age of herself as well. So she gave herself a different name and a different age. When she was being asked about like, why did you lie about this? Essentially, she was trying to say that she wanted to protect her identity. And the reason she wanted to protect her identity was because she was raised to avoid law enforcement, and she was raised to avoid conflict and to not insert herself into legal troubles, especially since her family immigrated over to this country, and that if she got into legal trouble, it could result in her family basically being deported. So essentially, she was saying without saying that her family was undocumented. So, but the defense just kept poking at this and was like, well, why would you lie about your age? Why would you lie and say that you were younger? Why'd you say you were younger? Why wouldn't you say you were older? And she kept saying, I already answered this question. I already answered this question. And they're like, no, you didn't. You answered why you lied, but you didn't answer about why you lied about that you were younger. Why wouldn't you have made yourself older? Like, all this stuff. And so they were like really going ham on her. And she was just visibly pissed off. Like, she was telling them, I'm not going to answer your questions. I have already answered that. I'm not going to sit here and repeat myself for you. Like, she was like throwing her mic off. Like, she was storming out of her chair. The defense knew how to press her buttons, and they knew how to piss her off. Then she gets to trial, right? So they've done the deposition, and now she's at trial, and she becomes just a terrible witness. In fact, it really, really hurts the prosecution's case. And it was so bad that people were laughing at her in court, and people were making fun of her on national television, on huge networks. Like, I feel so bad for this girl. And the prosecution didn't protect her at all. Like, here's the thing. As a lawyer, part of your job is protecting your witnesses. Like, you can't just leave them out there to be fed on by the wolves by opposing counsel, because if you're a lawyer, you have a doctoral degree in psychological warfare. You're a terrible person. I'm a terrible person. If I want to be, I'm the worst person to ever exist. I'm mean. And I'm not just mean. I know how to cut you where it hurts. How a witness looks, speaks, sounds like, and their demeanor is so vital in a trial. And I know that sounds stupid, but everything is judged so hard by the jury. The defense attorneys are judged. How are they dressed? Everything is ripped apart, including the witnesses, right? And that played a huge role here. And here's why. When Rachel Jean Tell was testifying, you could not understand her. Like, you couldn't hear her. Like, multiple times during her testimony, the jury would literally speak up, and they're not supposed to. They would literally speak up and be like, we can't hear her. We can't understand her. She is speaking on top of herself. She's mumbling. She's slurring. We don't know what the hell she's saying. The judge even admonished her several times, saying, you need to get closer to the mic. You need to speak up. You need to enunciate your words. We can't understand what you're saying. She did give an interview like several years later that, you know, she was really, really nervous and she didn't want to testify. Like, that she's not bred to go be a witness in a murder trial, and that she had never been in a courtroom before. And furthermore, she testified that no one even prepared her to testify. So she said all of that played a factor, right? Now, there's more things that play a factor in my personal opinion, right? There was the factor of the fact that she does come from a family of immigration, right? So it's most likely that English is not her first language, right? And that she predominantly probably speaks another language at home. This came out in the deposition that her family immigrated to this country, right? And she didn't talk too much about it, but she probably does not speak English as the main language in her home, meaning English probably isn't the most comfortable language that she speaks. The next thing that, you know, you need to analyze and go into was when you look at her testimony. She testified for a couple of days, and she testified for like 5 hours on the deposition. The placement of her physical features, she had a very, very severe underbite. So her top teeth, instead of being in the front, they were actually behind her bottom teeth, making her jaw protrude outwards. And because her jaw protruded outwards, her mouth was constantly in an open position with her tongue being exposed and slightly hanging out. And that was just because of the anatomy of how her jaw has been formed. And it also gave her this pretty intense lisp because of how much of an underbite that she had. And furthermore, you could see that she had begun the process of probably having braces to try to correct this bite issue. And if you have braces, it creates an even more difficult time to speak. It's painful to speak, and it creates even more of a lisp than she already had before, and it makes your mouth really sore. So the fact that the district attorney didn't put two and two together and didn't ask these questions, are you nervous to be here today? Why are you nervous? Have you ever testified before? Has anyone prepared you for your testimony today? No, this is the first time you've ever been in a courtroom? Yes. This is the first time you're being asked these questions? Yes. And then just be like, if I may ask, can I please ask about, you know, your dentistry work? Do you have braces on? You could paint this picture for the jury, because the opposite picture was painted of her. The picture that was painted of her was that she was an illiterate, uneducated, ghetto Black person. That was literally what she was labeled as in the media. What I just said to you is a quote, literally a quote unquote from mainstream media, like Fox News, all these other places, even CNN, MSNBC, all these places were saying these things about her. They did a terrible job about this poor woman. So she basically testifies to everything I already told you that she testified to in the deposition. The problem was, on cross-examination, she really got tripped up. She changed her story quite a few times, not by much, but she would have some inconsistencies that the defense would just attack, right? So they can attack her credibility. And the thing is, Don West knew exactly how to push her buttons because he already did it in the deposition. She was scoffing, she was rolling her eyes, she was making faces at him. She was even doing this motion with her chest, kind of like an aggressive, like, come at me, where she would like pump her chest and her arms forward. You could start arguing with the judge. She even started yelling on the stand, I ain't fucking coming back here tomorrow. Are you fucking kidding me? Like, it was bad. So then Trayvon's brother was called to the stand next. And he was called to the stand to identify the voice that was screaming for help on the 911 phone call. So this specific 911 phone call was a huge thing of evidence that was litigated against in this trial because both sides wanted the screams for help to be coming from their quote-unquote person. So Trayvon's brother listened to the phone call and he identified it as, yes, that is my brother screaming for help. But on cross-examination, the defense was able to negate this or discredit what he's saying on the stand because he showed Trayvon's brother a recorded interview that he did with a journalist. And when the journalist asked about that specific 911 phone call, he said that he doesn't know if that's his brother's voice, that he wasn't able to clearly identify if that was Trayvon or not, but that he does not think it was Trayvon screaming for help, right? And so the defense introduced that, was like, hey, you're saying that this is Trayvon's voice and that you can identify it, but you did an interview and you said the complete opposite. So the district attorney tried to rehabilitate this testimony, and Trayvon's brother went on to say that that interview bombarded him like a few days, like, or a week or so after his brother was murdered, and he bombarded him at school, that he was literally waiting at his school, pulled him aside and started asking him questions, and that when he was talking to the reporter, and this was shown on video, he was telling the reporter, you know, I just don't feel like this is real. I just feel like Trayvon is visiting family members and that he'll be back soon, that he's just on vacation. So when I listen to that 911 phone call and I hear these voices, it just doesn't feel real to me. Then Sabrina Fulton was called to the stand. This is Trayvon's mom. She was also played the 911 phone call. And when she listened to the phone call, she said without a doubt, she can identify the voice that was screaming for help and that this was her son's voice. She said, you know, between her just knowing how her son sounds, the high-pitched screams, the fact that the screams for help completely stopped the second that the gun was shot off, all of these things, right? And she was actually a really credible witness. They were trying to trip her up on cross-examination, but it really didn't work. She was actually the one thing that was slightly rehabilitating the prosecution's case together. Then a doctor by the name of Shipping Bo took the stand. And this is where it just gets even worse. This is honestly one of the worst trials I have ever researched and watched. So Dr. Bo was the doctor that did the autopsy of Trayvon Martin. And while he's on the stand, he was going over the pictures that he took during the autopsy and kind of describing the injuries that had occurred to him and the fashion and the way in which Trayvon had died. And he says that from where he was shot, which was like the right cavity, the right chamber of the heart, that Trayvon actually had a relatively slow death. That his heart kept pumping until there was no more blood left to pump because of the injury to the right cavity. The body or the heart had run out of blood to pump, but it pumped enough until it literally drained the heart of all blood. So then the district attorney asked him, are you able to formulate an opinion on the position of Trayvon Martin when he was shot? Was he on top of somebody? Was he beneath somebody? Was he standing up? Was he crouching down? Are you able to determine from the injury, from the trajectory of the injury, of how the bullet entered the heart and at what direction it entered the heart, are you able to tell what position that Trayvon was in when he was shot? And the doctor just freaks out. Like, I've never seen anything like this, but the doctor just freaks out. And the doctor says, and I quote, "I have no facts, I have zero opinion." And the district attorney just looks at him and goes, "You don't have an opinion? Like, you don't have facts?" And the expert witness, the doctor, is like going at him, be like, "The jury needs to understand my opinion, why my opinion is important." And the DA is cutting him off because he can already tell this witness is just getting away from him and it's going to go really badly. And he goes, "Yes, like, why you're credible to have an opinion. We understand that. We'll get to that later." But the witness is just going off. Like, the witness is really upset. And he continues on saying, and I quote, "You cannot rely on memory to testify, to say the truth, nothing but the truth, because you don't know the truth, okay?" And then he started demanding that he needs his notes. And he keeps saying this over and over again: "I need my notes, I need my notes, I need my notes." And he keeps telling the district attorney, "I don't have an opinion for you. I don't have any facts for you. I know nothing of this case because I don't have my notes. I need my notes." And the district attorney is literally laughing. He's literally laughing in court about this entire situation. And I don't understand. This district attorney is so fucking stupid, just to be like fully blatant and honest. I don't know how low the bar is in the state of Florida, but it's abysmal, okay? What Dr. Bao is saying is that it has been over a year since I did this autopsy. And when I did the autopsy of Trayvon Martin, I took personal notes. I took personal notes of all the injuries, of the testing that I did to see at what angle the bullet could have gone into the heart, to see how far away the gun would have had to be to make this type of residue and this type of hole and this type of blunt force trauma into the heart. All this is going to be on my notes, and I can't remember it off the top of my head, so I can't give you an opinion. I can't give you facts because I don't know it. I need to see my notes. I need to see my notes. And this is so fucking frustrating because all what the district attorney needed to say was, "Dr. Bao, did you perform an autopsy on Trayvon Martin?" "Yes." "When you performed this autopsy, did you take notes?" "Yes." "When you took these notes, because of the close time and proximity to the autopsy, is it the best of your recollection when you took the notes then, or going off of your memory now?" He'll say, "No, my memory was better as I was taking notes, as I was performing the autopsy." "Okay, Mr. Bao, and would it help refresh your recollection of these details if you were able to look at your notes?" "Yes." "Okay, you have permission, Mr. Bao. Can you please turn your notes over? Look at them, and when they refresh your recollection, can you please turn them back over and look at me?" And the thing is, a witness is not allowed to read off of their notes, right? That's improper refreshing of the recollection. But they're allowed to look at it to refresh the recollection and then turn their notes back over. So when Don West goes and does cross-examination on this doctor, he finally tells the doctor, like, "Oh, do you have your notes with you?" And the doctor says, "Yes, I have my notes. Can I please look at my notes?" And Don West goes, "Well, can I have a copy of your notes?" Which he has the right to. And the doctor says no. He says, "No, I would rather you not be able to look at my notes. I was the one that wrote these notes. I was the one that used my time on the weekends, and I was the one who used my time in the evening to write these notes. So, like, you don't get to look at my notes." And so the defense attorney is like, "Okay, Your Honor, I would ask him to be excused from the stand and all of his testimony to, like, almost be stricken because he won't freaking comply with the rules of evidence." Instead, Don West just let this doctor keep speaking because, again, the doctor's really angry and he's making outbursts and he's literally yelling and arguing with the defense attorney. He's arguing with the judge. He's arguing with the prosecution. And again, as a defense attorney, if a witness is up there and hostile and angry in a loose cannon, quote unquote, we're going to let him keep going. So something else that I want to point out was that Dr. Bao was an Asian immigrant to America, right? And it was very obvious that English was not his first language. Like, very obvious that English was not his first language. You could hear through his accent, as well as the fact that his sentences weren't grammatically correct in English. The defense really was able to hone in on this and basically twist all of his words to the point where Dr. Bao was yelling at the defense because he was so frustrated. So Dr. Bao said, "I cannot remember anything from this autopsy." And as he's trying to continue, he asks the defense attorney, "Okay, like, I can't remember anything from this autopsy. Can I explain to you why?" But the defense cuts him off. "Okay, so no," and he says this, and I quote, "Okay, so no one knows the autopsy like you, but you can't remember a single thing from it?" And he goes, "Yes, I can't remember a single thing from it. 0. And he literally puts his hand up and makes a 0 as he says that. And the defense was very tactical and very ugly here. They knew what Dr. Bao was trying to say. He was trying to say, "I know the autopsy perfectly through my notes. I conducted this autopsy. I have a medical degree and being able to perform not just autopsies, but autopsies in a criminal nature, right? From murder. And I took extensive notes. But it has been over a year since I did this autopsy, and I have done hundreds of autopsies since then, and I cannot remember the answers to your questions. But if I look at my notes, I'll be able to remember, and I'll be able to give you the answers to your questions." And this is why, ladies and gentlemen, it is a huge fucking issue that the legal system is predominantly made up of old white American men. Because any young lawyer, especially any lawyer that's a person of color, that specifically has parents that immigrated to this country, they know exactly why this witness is frustrated. And they know 100% that the lawyers are just twisting what he's saying, and that's why it's frustrating him. And they know what this witness is saying, but it's not coming off in a palatable, quote-unquote palatable manner that a multiple generation white American would like. This witness is excused. The district attorney calls their next witness, a man by the name of Jonathan Good, and he was an eyewitness to this crime scene. And the police state that they believe he's the most credible eyewitness to this case because other eyewitnesses did come forward, and they did say that they saw like some of the fight, but they were too far away, so they really couldn't see any details. And other people were saying, like, "I heard the fight, but I was too scared to go outside. So I don't really know what happened. I just heard cries for help," right? But John Good actually saw what happened. So when he gets onto the stand, the district attorney asks him, "Did you see anyone getting their head slammed on the concrete?" He says, "No. No one ever got their head slammed on the concrete." He says, "Did you see anyone repeatedly getting their head slammed on the concrete?" He says, "No. Again, no one ever got their head hit on the concrete." He was asked, "Did you see any motion where someone was pulling up a body from the ground and repeatedly bringing it up and down?" He said, "No, nothing like that ever happened. Like, that did not happen." He also says that he knows that wouldn't happen, not just because he saw it, he saw the whole altercation, so he never saw somebody getting their head smashed in on the concrete, but he also said that the people that were in the fight were approximately 10 feet away from the concrete, and they were only in the grass. So nobody was ever on the concrete during this altercation. The reason why he saw this altercation was because he was in his home and he heard somebody yelling for help repeatedly. And when he got outside, he saw these two men fighting. And he said that he saw a person that was wearing a darker sweater, who was black, was on top of somebody who was wearing a lighter sweater that he believed was either red or white, and George Zimmerman was wearing an orange sweater that night, and that he was definitely lighter in color than the person that was on top of him. So he testified somewhat to Zimmerman's story that Trayvon Martin was in fact on top of Zimmerman. And he did say, "Yes, I saw a few punches being thrown down onto the person that was wearing the lighter sweater that was on the bottom." Now, he testifies that he did not see the actual murder because he ran back into his house to grab his phone to call the police, and that he didn't come back out of his home until after he heard the gunshots. And after he heard the gunshots, he came back out and he testifies that he saw two gentlemen with flashlights at now the murder scene, and that the person that was on the bottom of the fight was now standing erect, was now standing up, and said, "I shot him in self-defense." So with this, the prosecution now rests their case. And now the defense calls witnesses to the stand to put on their case for their case of self-defense. And they put on Jorge Meza, who is George Zimmerman's uncle. They put on a woman by the name of Jerry Russo, who was Zimmerman's old co-worker, a woman by the name of Sandra Osterman, who was Zimmerman's friend, a man by the name of Mark Osterman, who was another friend of George, and a few other people. And for all these people, they played the 911 recording. And they asked, "Can you identify the voice of the person who is screaming for help?" And all of them identified George. The uncle, Jorge Meza, he stated on direct examination, "That is my nephew. I don't just hear him screaming for help. I feel him screaming for help. I hear him screaming for his life. That's George." Zimmerman's co-worker, Jerry Russo, she testified, "Oh yeah, when I heard that voice, I knew right away it was George's. I've heard George's voice for years." His friend Sandra Osterman, she said, "Immediately I knew that was Georgie's voice." And then Mark Osterman said that he knew that it was George's voice because Mark used to be a combat medic. And so he knew the sounds of screams, and he knew the sounds of terror, and he knew the sounds of death. And so he has the ability to be able to hear those screams of death, which usually alter your voice, and still be able to place it with the correct voice. So more issues with the district attorney just forgetting the evidence code and forgetting how to fucking object. Was not only did they not object to that, but they also didn't object to any of the character evidence that the defense was bringing on. So in the state of Florida, the law says that if the assailants, the quote-unquote assailants, do not know each other, you are not allowed to bring forward character evidence. But the defense did this. They asked improper questions about character, and they got these witnesses to say really stupid shit, like George Zimmerman used to tutor children for free, and he would donate his time to helping the youth, and all this other stuff to really humanize George to the jury and make these women see him as this like paternal figure that just cares for the children and cares for the youth and wouldn't want the youth to be dead. Eventually, the defense called 7 witnesses to the stand that identified that voice that was screaming out for help was George's, whereas the state only called 2. Then a man by the name of Dennis Root was called by the defense to the stand, and they were putting him on as an expert witness in combat as well as an expert witness in force, especially excessive force. And at first, the district attorney was actually doing a really good job at cross-examination, right? So they were able to get the witness to admit on the stand that, yeah, the laceration on the back of George's head was really small, and that in fact, it was only 2 centimeters, and that it wasn't even deep, that it was a very superficial laceration, and that this laceration is not theoretically possible or compatible with the story of getting your head slammed against the concrete multiple times. He also testifies that, George did decline medical treatment, so we have no idea to what extent his injuries were, but if your head was being slammed against the concrete multiple times, you would have severe fractures to the back of your head, and you would have internal hemorrhaging and bleeding of the brain. The witness just admitted that the laceration is really small. It's not really consistent with being slammed against the concrete, but then the district attorney decides to bring out a human-like dummy. I don't know why. And he puts the dummy on the floor, and he begins to recreate everything that George Zimmerman is alleging. He literally is recreating it. He's on top of the dummy, and he's saying, okay, so George says that his knees were right here in regards to George's chest, that Trayvon's knees were at his pectoral areas right under his armpits. Is that correct? And he's like, yeah, that's what George says. And he's recreating. He goes, okay. And then George says that he was slamming his head against the concrete. And as he's doing, he's picking up the dummy and viciously slamming it and hitting this dummy. And he is burning into the jury's mind a visual representation of what George is alleging happened to him. Like a brutal reenactment of what George is saying is possible, instead of focusing on the fact that what George is saying is impossible, which the district attorney didn't, right? District attorney really didn't go into brain hemorrhaging, the probability of getting a concussion from getting your head slammed against the floor so much. They didn't go into any of that about how it's impossible, because none of George's injuries matched the injuries that he claimed that he would have sustained from what had allegedly happened. All what they got him to admit was that, yes, the laceration was really small. Then we get to a witness by the name of Olivia Bertolin. I don't know if I'm saying that correctly, but Olivia Bertolin. And she was a former neighbor of George. And she was called to the stand because she testified that a crime was committed against her several months before the murder of Trayvon Martin. And she testified, and I quote, "I was home on a Wednesday with my son, who was 9 months old at the time, and I heard someone ring my doorbell. When I looked out the window, I saw two young African-American guys wearing blue shirts, so I just assumed that they were with a company or something. But they wouldn't go away. They kept ringing my doorbell over and over again, and I just knew it was bad. I called 911, and they said to get to the farthest room and grab anything you can use for a weapon. I heard them come up the stairwell, and he was shaking the doorknob trying to get in. There I was with a pair of rusty scissors in one hand and my 9-month-old son in my other arm, and then the police finally came. They had stolen my camera, my laptop, and they had tried to steal my TV." So she testified that after this incident, George Zimmerman actually came over to her house after it was burglarized and broken into when she was home with her 9-month-old son, and that George had brought her a lock for her sliding glass door, and that George offered her to come over to his house whenever she was scared and be able to hang out with his wife, right? And she testified that her and George probably talked about this incident at least 20 times. So Olivia goes on to testify that a couple months after the break-in, somebody was arrested, and it was a 17-year-old African-American male that lived in the apartment complex or in the gated community on the other side of the complex, of the townhouse complex. And basically, this 17-year-old didn't get in trouble at all. Because he was underage, he essentially just got like a slap on the wrist. He wasn't arrested. He wasn't given jail time, nothing like that. Just a little slap on the wrist because he's underage. So what the defense is trying to do here is insinuate that when George said, you know, these punks, these assholes, they always get away with it, it wasn't because Trayvon was black. It was because these teenagers had been burglarizing all of the residents, and they've been quote unquote getting away with it because they've only gotten slaps on the wrist instead of jail time. And here with this witness, what the defense is essentially trying to paint for the public was George's state of mind, right? They're trying to paint that he was in reasonable fear for his safety and his life because this neighborhood had become so crime-ridden. There was so many home invasions, there were so many burglaries, there were so many robberies, some of them armed. They were even happening when these poor women were alone with their toddlers and their infants with nothing to defend themselves, and they're trying to break into the bedrooms and get them and get their children, and they should all be so scared because there's all these thugs and these criminals running around. Where the prosecution insanely failed is, one, they should have objected to this. They should have argued like hell in motions in limine to keep this out. They never argued for it, but they should have argued to keep this out in motions in limine because this does absolutely nothing for the defense. It doesn't have anything to do with Trayvon Martin, and it really doesn't have much to do with George Zimmerman's state of mind. And this is a tactic that is very well used, and they played it out here. And this should have been argued in a 403 balancing test, that this was just prejudicial and it was not probative. It was just going to ignite emotions and fury into the jury, and fear that that white woman could be them, that they can see their whiteness in that white woman, and that them and their kids, and they need protection too, and they all have the right to be scared because these 17-year-old African-American kids are just burglarizing and trying to harm white women. That's pretty much what the defense did. They say they didn't. They've given interviews after that saying that they take offense to that argument. At least Don West has. But in my opinion, that's exactly what they did. So now we get to closing arguments. The defense has rest, the people have rest, and now we are getting to closing arguments. And DDA Richard Manti, he was the first district attorney to give the first closing argument. And he had a lot of emotion in his voice, and you can feel it. Like, his voice is breaking, he's angry, he's screaming. There's a lot of emotion in there. But some of the things was that, this is a closing argument. And Richard, the district attorney Richard, he was asking a lot of questions to the jury, and I understand what he was asking. It makes sense, but don't leave the jury with questions. Leave the jury with answers. Leave the jury with conviction. You tell them what happened. You argue the evidence. You don't question the evidence for them to question, right? So he would say stuff like, if Trayvon Martin was punching George, then why didn't he have bruises on his hands? If George was defending himself, where are the bruises on George's arms? These should have been statements. He should have painted a picture, right? And I just wrote out in like 5 seconds a picture that he probably should have painted. A fist fight, physical combat, fighting for your life, pounds and pounds, hundreds of pounds of flesh and bone being slammed against each other. When physical trauma like that happens, the body reacts. It is medically impossible for the body to not react to trauma. It swells, it bruises, it becomes red. There is physical evidence of blunt force trauma, always. There's physical evidence of bruising even when you just stub your toe on a corner. So imagine then, someone trying to murder you by slamming your head into concrete. Somebody trying to murder you by punching you to death. There would be physical evidence of that. And here, there's none. The evidence shows that George Zimmerman is lying. George Zimmerman lied to the police. He lied to the police when they arrived on scene. He lied to the detective when he went to the police station. He lied to the detective the next day when he did a reenactment. And then he lied to the news cameras. And he's lying here today. And the evidence proves that. The evidence showed that the fact that there's a lack of evidence, that there's a lack of any bruising consistent on Zimmerman's or Martin's body is all the evidence that you need. Medicine does not lie. The body does not lie. A deceased body without any physical trauma besides a gunshot wound cannot lie. Only a living, breathing man can lie. That's probably how I would have started my my closing argument. I wouldn't have started it by asking questions. So then the defense gets up, and it was Mark O'Mara who gave the closing for the defense, and they didn't do anything radical. They didn't do anything great with their closing, but they stuck very true to form. They just stuck with the law. They just stuck with the evidence that they had. They just stuck with their theory that this was self-defense, right? And they were just arguing the prosecution didn't prove beyond a reasonable doubt that this wasn't self-defense. The prosecution didn't give you any evidence to say that George Zimmerman was not in fear of his life. They didn't give you any evidence to say that his fear was unreasonable and that George was in fear of bodily harm or death, either one, that George was attacked by Trayvon Martin, and there's no evidence to the contrary. There's no evidence for or against it. There's no evidence at all. So because none of this is proven beyond a reasonable doubt, you have to vote not guilty. You have to take my side because there's no evidence. Nothing was proven. Then the other district attorney, DDA guy, John Guy, he gave the second closing because district attorneys always give a rebuttal closing because they have the burden of proof. They close first, then the defense closes, and then the DA gets back up there to rebut everything the defense said. And he actually did a really good job with his closing argument. The issue, though, was that he was bringing up a lot of really good points that he should have brought up during the trial through cross-examination and direct examination, and he didn't do it. So now he's making these arguments that people are hearing for the first time ever, that he has no evidence to back up of it, right? He didn't bring forth evidence of the body trauma or lack thereof. He didn't really bring forth the evidence of how imperative it was that George Zimmerman refused medical treatments, right? he didn't bring up all these things, but then he was trying to argue about it in his closing. So it was just a miss. It was a great closing, but it was a miss because there was no evidence to back it up. The jury came back and it was unanimous. All 6 white women voted not guilty for George Zimmerman, and he was acquitted of murder. Now, it should be noted, after this trial, several things have occurred. The police were called by George Zimmerman's, at the time, wife, now ex-wife. So 2 weeks before George Zimmerman's wife called the police, she actually filed for divorce. And she was citing, even before this trial, like even before Trayvon Martin was murdered, she actually was in the process of separating from him. She said that she went to go live with her parents because she was living with a George she's never seen before. He was very violent and very angry. And that 2 days before the murder of Trayvon Martin, George had come to her parents' house and asked her to come back home. And she said, not until you get your anger under control. But because he then murdered Trayvon Martin and was facing trial, she didn't want to leave him, and she wanted to help him because she was his wife, right? But his violence and rage just escalated after this murder. So she calls the police, and you can hear all this happening in the background of the phone. You can hear things being thrown, things being broken. You can hear George screaming on the top of his lungs, and she's telling the police, please come help, please send help. George is punching my father. He's beating my elderly father, and he keeps grabbing a gun and pointing at us and threatening that he's going to kill us. George was not arrested for this crime, and no charges were pressed. So after this, a new girlfriend of George had called the police, and she went in and actually did an investigation with, like, an interrogation with the police department, and she said that George had been beating her, and that George had done a significant amount of domestic violence against her, and that George actually grabbed his shotgun and pointed it to her head. Eventually, like, the police officers were like, why haven't you reported any of these prior bad acts of domestic violence? And she said, because he always gets away with it. And he told me he got away with murder before, he could get away with murder again. And eventually she ended up recanting her story. So the district attorney had to drop all of the charges, and she ended up recanting her story and said she lied. And basically she was telling the district attorney, I need the charges dropped because I'm terrified of him. And I'm not going to come to trial and testify against him. And it actually happens a lot. I was in domestic violence court for about a year, and I will say about 70% of my cases were dismissed because the complaining witness ended up recanting. Now, I'm not saying that they were all recanting out of fear. There were a significant amount of women. Of that 70%, I would say maybe 40% just admitted that, like, they were lying because, like, the defense presented evidence against them and sent out investigators against them to prove that they were lying, so they ended up recanting, whereas the other maybe 60% of those women just recanted because they were scared and they didn't want anything to do with this anymore. There was, again, no charges pressed, charges were dropped. Then another phone call came in from a new girlfriend of George Zimmerman, and George got insane road rage one day when they were driving in the car, and he took a glass bottle and broke it over her head and threw her out onto, like, the freeway, essentially. And she's freaking out on the body-worn camera and saying, how is this man not locked up in jail? He's dangerous. Like, he's dangerous to the public. And she's, like, freaking out. And again, no charges were pressed. No charges were filed. George Zimmerman was prosecuted, though, and he pled no contest to stalking and threatening a private investigator. So there was a private investigator that was doing research on the Trayvon Martin trial, or Trayvon Martin murder. And while he was investigating George had gotten his phone number and sent him a lot of threatening text messages, and basically that he could get away with murder. He's done it before. He should watch his back. He's going to feed his body to the alligators, all this crazy stuff. And he would call him, leave him voice notes or voice mails. He wouldn't say anything, but he'd be, like, playing music that would get louder and louder and quicker. It was really weird. And there was evidence and testimony that George Zimmerman would drive by his house and, like, watch his children play and, like, threaten his children. George Zimmerman also encountered the police yet another time when the police were going to arrest him, but no charges would be pressed. And on the body-worn camera, you can hear and see George say, "You're just asking for my ID and you're just pulling me over or trying to arrest me because you are a N-word lover." And the police officer goes, "That's not appropriate. Like, do not say that." And he just keeps chanting at him, "N-word lover, N-word lover." And then he says on recording again, "They're not called black people, they're called monkeys." And there's actually several recordings, audio recordings of George Zimmerman making this statement even before he murdered Trayvon Martin. And since being acquitted of murder, George Zimmerman has begun selling paintings of Confederate flags for thousands of dollars. He sells paintings of the Confederate flag with his signature on it. He also always keeps Skittles in his pocket, right? So of course, as we know, Trayvon Martin, when he was murdered, he was found with Skittles and an iced tea, right, on his person. So George Zimmerman always keeps Skittles in his pockets, and whenever a white supremacist comes up to him and congratulates him on murdering Trayvon Martin, he'll take out a bag of Skittles and sign it and give it to them. Also auctioned off the handgun that was used to murder Trayvon Martin, and he sold it for around $150,000, and he labeled the gun on the auction website an American firearm icon. And he donated a portion of the proceeds from the sale of the gun to, and I quote, "to fight Black Lives Matter violence against law enforcement officers, ensure the demise of Angela Corey's persecution career, and Hillary Clinton's anti-firearm rhetoric." So to understand this, you need to understand that after the acquittal of Trayvon Martin, so in order to understand this, you need to understand that after the acquittal of George Zimmerman and the murder of Trayvon Martin, Black Lives Matter was established. That is when the movement was established, and it was actually established through Twitter with the hashtag Black Lives Matter. And it became a movement, it became a march, and this was the first time that all these marches were happening in the name of Black Lives Matter. And it became an organization to fight for the lives and justice of African American citizens. And then Angela Corey was the special prosecutor that decided to charge George Zimmerman with second-degree murder. And then Hillary Clinton's anti-firearm rhetoric. Well, what happened was at this time, Hillary Clinton was running for presidency, right? And Hillary Clinton specifically hired on Trayvon Martin's mom to come work on her campaign. Specifically, she hired on Trayvon Martin's mom to be the spokesperson for gun restriction and to repeal the Stand Your Ground law. So to dismantle the Stand Your Ground law, to take it away because it was just an open license to kill people. And she was the voice for Hillary Clinton for gun control. And so pretty much he wanted to use the money that he made for murdering Trayvon Martin to dismantle and tear down Trayvon Martin's legacy. His legacy of fighting for civil rights and equality for African American people in his name, and his legacy of his mom fighting to save people's lives through gun violence and taking down this law. He's a real winner. Great person. And with that, the story of the people versus George Zimmerman comes to a close for now. I think there's a lot that everybody has learned on this past 2 weeks of the podcast. And I think there's still a lot more to learn. And there's a lot more research that you can all do on your own, or I can make a follow-up part 3 to all of this, as this case was a very pivotal moment in American and legal history. There's a huge backstory on the NRA and how the NRA actually got the Stand Your Ground bill to pass. There's also a huge story on the Stand Your Ground showing empirical evidence that you cannot argue with about how racist it was, how it was basically a license to kill people of color and get away with it, the civil liability that happened to police officers that were trying to fight against this bill, and the hands that were bound through the prosecution side when people argued the Stand Your Ground. I think there's a lot more to learn about that. I think it was a huge, huge role on the outcome of this case. And that was even proven with jury members giving interviews after the verdict saying that basically they had to acquit him because of stand your ground. Even though the defense wasn't even arguing it, it was just slipped into the jury instructions. There's a lot of details on this case that I can't break down in just 2 episodes, right? And also, as you know, we've all learned here today, the Black Lives Matter movement was started because of the acquittal of George Zimmerman in the murder of Trayvon Martin, and all that that has had on our legal system and our judicial system as well, with the movement of the Black Lives Matter group. I implore you to learn about all this on your own and do your own research. And if you want to hear or learn more about it from the research that I do, then please let me know. The story of the People versus George Zimmerman is coming to a close. And with that, may Trayvon Martin rest in peace. And so far, the defense rests.